Hello and welcome back to the channel. Today we'll be discussing about how to register a trademark in the Philippines. Before we move on to the step-by-step process of trademark registration in Philippines, let us first discuss how does the law of Philippines define a trademark. A trademark according to the law of the Philippines is one that is capable of identifying the source of goods to which it is affixed and distinguishes the owner's goods and services from those of others. This is the reason why generic marks or descriptive marks cannot be registered as trademarks according to the laws of Philippines. Thus, any sign that is visual can be registered as a trademark in Philippines, such as figurative marks, word marks, slogans, color marks, composite marks, position marks, 3D marks, motion marks, hologram marks, collective marks, etc. Therefore, those marks that are not visually perceptible cannot be registered as a trademark in the Philippines, such as sound marks, smell marks, taste marks, touch marks, etc. In the Philippines, the practice followed for the trademark registration is the first to file trademark system. The rights associated with the trademark are conferred on the applicant after the proper registration of the trademark in accordance with the law. However, well-known marks are recognized in Philippines even if they are not registered in the Philippines. Let us also discuss who is eligible to file an application for the registration of trademark in the Philippines. An application for the registration of a trademark in the Philippines can be filed by a natural person or a juristic person. In the case of foreign applicants who are not domiciled or have a real and effective commercial establishment in the Philippines, they need to have a local resident representative who will be responsible for correspondence with the local authorities with respect to the notices being served or the processes affecting the trademark. A trademark application can also be filed by more than one applicant, and all such applicants will be considered as co-owners of the trademark. Let us now discuss the step-by-step process of registration of a trademark in the Philippines. Step 1 involves filing an application for the registration of a trademark or collective name. Before making an application for trademark registration, it is suggested by the trademark consultants at Enterslice to conduct a comprehensive trademark search to ascertain the availability of the trademark, the existence of already registered trademarks in order to avoid the chances of objections and oppositions with respect to the proposed mark. Along with the mark, it is also advised to do a comprehensive company search and domain name search regarding the trademark. In the Philippines, the applicant has the option of filing multi-class or single-class trademark applications in the Philippines. Trademark applications in the Philippines can be filed using any of the following two methods, namely ordinary applications and conventional applications. The minimum cost per filing per class is 1200 Filipino peso in the case of small entities and 2529 Filipino peso in the case of big entities. Step 2 involves substantive examination of the application. After filing the application for trademark registration, the application undergoes the process of the examination process. The IPO-PHL, which is a statutory body, examines the application to check whether all the legal requirements have been met or not. If the IPO-PHL finds that the application meets all the requirements for the registration purposes, then it will publish the application on the payment of the applicable prescribed fee. If the IPO-PHL finds that the applicant is not entitled to registration, the office will state the reason for the same and also advise the applicant to rectify the deficiencies. The applicant is given a period of 4 months' time to reply or to make the necessary amendments to the application, post which the application is again re-examined. Once the final decision has been given by the trademark examiner and the applicant is aggrieved by such decision, the applicant has the option of filing an appeal before the Director of Trademarks. The final decision of the Director regarding the refusal of the trademark registration can also be appealed before the Director General. Step 3 involves publication of the trademark for inviting opposition. After the successful completion of the examination stage, the application for trademark registration is accepted and published in the Trademarks Journal for third-party observation. The publication is made in the Trademarks Journal because the office wants to give an interested party an opportunity to file opposition if such a party believes that the registration of the proposed mark will cause damage to them. The opposition from the interested party has to be made within a period of 30 days from the date of publication of the trademark. Where the interested party shows a good cause for the opposition, then the period of filing the notice of opposition can be extended by the Director of the Legal Affairs. Step 4 involves issuance of the certificate of registration. In case no notice of opposition is filed or the time period for filing the opposition is over, or the Director of Legal Affairs denies the opposition claims after hearing the opponent's submissions, the office can proceed further with issuing a certificate of registration to the applicant, provided the applicant has paid the required fee. The final step involves publication of the registered trademarks or collective marks. In case no opposition is made or where the opposition was raised and decided in favor of the applicant, the application shall proceed towards registration of the trademark. The trademark is registered for a period of 10 years from the date of registration, and the certificate of registration is issued in favor of the applicant. Thereafter, the trademark gets published in the trademarks register. Let us now discuss the information that is supposed to be submitted along with the application form for the registration of trademark in the Philippines. 1. Full name and address, nationality, citizenship, or the place of registration of the applicant. Fill out 2 copies of the trademark application form. 3. Drawings of the mark. 4. The title of the trademark. 5. The list of services and goods covered by the application and the corresponding niche classification. 6. In case priority is claimed, then the country, date, serial number of the previous application along with a copy of priority application. 7. Where the applicant wants to claim colors, the name of the color should be mentioned. 8. In case the proposed mark is 3-dimensional, then the indication of such 3D mark. 9. Where the application is not filed by the applicant, then the signed power of attorney which authorizes the filer to file the application on behalf of the applicant has to be filed. And 10th, the full name and address of the local agent, authorized representative of the applicant has to be provided. For more such information, please subscribe to the channel.